everybody, ladies and gentlemen. I'm honored and pleased to be given the chance to have a word with you, to have a conversation in which I'm going to try to be useful. But first of all, let me thank you. Let me thank you, Mrs. Owen, Nora, if you allow me.
Yes, that's right.
Attorney General Gallagher, it's an honor to have you here, and all of the members and staff of the Institute for European Studies. It's for me a privilege to be here in Dublin and having an opportunity to exchange some views about the role I'm playing in this puzzling situation in which the whole of the European Union and beyond that, the whole of the European construction project and idea is this particular point of time. First of all, I'm sure you know that it is impossible to say a word about the state of affairs within the European Union without making the compelling point about this huge crisis that we're fighting against from a certain period of time to this day. Yes, it's the hugest crisis we've seen so far. It's the deepest crisis we've gotten to know in our lifetime, and the point is just naturally, whenever we talk about Europe, we talk about the financial burst of the real estate bubble, the way it impacted on real economy, the way it has damaged our social fabrics within every member state and across Europe, the way it's destroyed millions of employments, jobs, and so it has shown a human face. Of course, we are all aware of that. I'm a Spaniard. I'm aware of that because many of those jobs that have been destroyed over this crisis have been destroyed in Spain. So we are concerned. But having said that, I care to highlight that Europe is not going to be made out of the success of the single currency. Europe is not going to be made out of the success of the single market. We've got some experience about that this far. Europe is going to be made out of the success of European citizenship. I got no doubts about it. And that's my major concern. Because if Europe is not made out of citizens, people, real people, men and women, sharing some common set of values and enjoying a certain standard of rights and liberties, which are complementary to all of those rights and liberties that we enjoy for the sake of being citizens of every of the member states of the European Union, which do not diminish in the least the joy of being citizens of each one of our member states, but on the contrary, enrich us and makes us greater because they are European and they are brand European, precisely because they make us wider and somehow bigger than we are for the sake of being member states of the European citizens, of the European member states. If not for that citizenship, Europe is not going to have a future at all. So I do care about this field of action in which I am devoting time and playing a role in the European Parliament. I happen to be chair of the LIBE Committee, the committee in charge of civil liberties, justice and home affairs. And I truly think that, first, it's the most active, vivid and productive committee in the European Parliament in this particular point of time. But more than that, I would say that the field of action of the LIBE Committee happens to be the field of action in which the political dimension and constitutional ambition of the whole European idea is best expressed. I truly think so. Because it's about precisely the incorporation on the European project of the idea of citizenship, liberty, rights, and a whole range of issues which just yesterday were still the exclusive realm of member states' jurisdiction, somehow open to intergovernmental cooperation under the structures of so-called third pillar. But after Lisbon, this whole thing has for the first time been Europeanized, somehow has been made subject to European legislation. What was called co-decision, now it's called ordinary legislative procedure, and therefore subject to the jurisdiction of the European Court of Justice. So all of these third pillar matters now have come forward as a European field of action, which is much compelling. There is much to be done, and it's going to take time. We're talking about here of very important issues, and each one is expressed in a major step forward being made by the Lisbon Treaty finally entered into force. Article 3 and Article 6, I mean, you know the Lisbon Treaty, yeah, we got it. I've been just granted this consolidated version, of course.
Has read it three times.
Of course, this Lisbon Treaty encompasses a consolidated version of the Treaty for the European Union, a consolidated version of the former Treaty of the European Community, now called Treaty for the Functioning of the European Union, and a European Charter of Fundamental Rights, which is also an ingredient, which is also a component of the Lisbon thing. And we got that in Articles 3 and 6 of the consolidated version of the Treaty of the European Union. We got some references being made about the importance of liberties and rights. We got in Article 6 the mandate for the European Union to join the European Convention on Human Rights, which is going to be the grounds for a not yet seen dialogue between legal spheres of protection for human rights and fundamental rights, and more than that, a dialogue between judiciaries and court systems. The European Court of Human Rights in Strasbourg, in open dialogue with the European Court of Justice in Luxembourg, and both of them in open dialogue with the judiciaries of each one of the member states. Whatever that structure might look like, they are now invited to keep an open dialogue with these major courts dealing with rights of citizens. We got, besides that, in the Treaty of Functioning of the European Union, Articles 67 to 89. If my memory is not failing me, Articles 67 to 89 are the articles referring to the so-called space area for liberty, justice, and security. Liberty, justice, and security, which means citizenship, European citizenship, and as opposed to European citizenship, foreigners across Europe, asylum seekers, refugee seekers, migrations, the external border of the European Union and its management with common instruments, and a constellation of agencies serving that purpose. We got civil judicial cooperation in order to enhance not only commercial traffic, but also economic growth and employment, which is functional. And we got police and judicial cooperation in criminal matters, most delicate, against transnational transnational organized crime. And some of the most relevant forms of transnational crimes, which each one of the member states has a duty to fight against. Illicit trafficking of human beings, narco traffic, arms traffic, corruption, the laundering of the illicit money which illicit traffics produce, and of course terrorism. So these are not only issues of essence, of the utmost importance, but also most delicate matters, because they challenge the deeply rooted basis of each one of our legal systems, of the national legal systems, and they challenge the true will to cooperate, to exchange views and seek for solutions which are common shared. And they challenge our ability to serve our citizens upon the certainty that there is no way we can make it acting each one of us on our own. There is no way we can make it. There is no way we can be of significance, for instance, in order to prevent migrations, illicit trafficking of human beings, so illegal migrants, and the human exploitation that is related to all of these phenomena if we do not act together on the basis of trust, on the basis of the overcoming of national prejudices or inertia, and an active, proactive, positive will to come closer and to put forward brand new solutions, newly invented, just in order to make the difference that we must make if we are to be of significance to our citizens. So it's a fascinating area. And I was just, in a previous conversation, just making a point which I would like to share with you. And it is that most usually, in order somehow to publicize the basic ideas of the Lisbon thing, somehow we have been invited or dragged into the simplification rhetoric, with the allegation that the Lisbon Treaty would simplify the previous state of things, the previous state of affairs, that Lisbon Treaty would mean a simplification regarding the complexity and the unmanageable mixture of heterogeneous ingredients that were related to the previous legal structures, which we called Nice or Amsterdam or even Maastricht. But the fact of the matter is that that's not the real picture. Lisbon Treaty is not going to simplify our lives, not particularly in this respect, not particularly in these matters. It's going to make it more complicated and more demanding. Because not only both under the technical and political points of view, the requirements have gotten higher. The level has been raised, not only because of it, but besides because now the European Parliament, which has gone so much stronger with Lisbon, now the European Parliament is mandated to keep a permanent and open dialogue with the national parliaments of the member states, not only to assess and evaluate on a regular basis all of the progress that are to accompany the implementations of the pluriannual strategies that are to be adopted in order to fulfill the goals of the area of liberty, justice, and security, but also because it is a fact that the regulations and directives that are going to be adopted under the so-called now ordinary legislative procedure are to be complemented with national legislation. They are not to overrun or ignore national legislations, but simply to shed light on national legislatures, on national parliaments, so that they can follow a track which is going to demand a common effort on a permanent basis, highly demanding. So we got this complicated situation regarding this fascinating area of content of the Lisbon Treaty, and I'm sure you know that one of the first tasks we have fulfilled was precisely the adoption in Parliament of a resolution regarding the pluriannual strategy, which is to implement the goals of the range of issues I'm talking about. We made it with the occasion of the so-called Stockholm Programme. The Stockholm Programme is to succeed the previous Tampere Programme adopted in 1999 under Finnish presidency, and the De Hague Programme adopted in 2004 under Dutch presidency. Now we got this Stockholm Programme adopted in 2009 under the Swedish presidency, which is to be specified in a 5-year term set of actions which has been defined under Spanish presidency by the name of a Plan of Action for the Stockholm Programme. We have been discussing this kind of issues. And I would only refer to the additional complication which is related to the fact that many of the ingredients of the so-called third pillar acquis are now to be Lisbonized, which is going to take time. It's going to be a very complicated task. We're going to spend, I'm sure, we're going to spend much energy, because we have done progress. You know, all of these issues were not involved in the European project right from the beginning. The European Union was basically commercial and economic for some time, and just with the passage of time, with progress, the idea of citizens, liberties, securities, these kind of things, judicial and home affairs cooperation, emerged as a new dimension of the European construction. Well, all of these steps that have been made with all of these difficulties, much through political will, are now to be Lisbonized. It's going to take time and energy. It's going to be subject to much discussion. And I'm sure that many of the aspects of this horizon we got ahead of us are going to make our life truly complicated, not only within the LIBE Committee, but in all of the European Parliament. And I would relate, finally, this consideration to a particular mention of the balance we've got to strike between two classical dimensions of liberty, which are civil liberties and security. Civil liberties and security. This is an issue that has been discussed not only once, more than once, many times and thoroughly. In just 1 year of the current European legislature, for good reasons. First of all, I've got to say that I have trained myself as professor of constitutional law in a country which is used to strike the balance between liberty and security. So you all know that Spain adopted a constitution that ensured the consolidation of democracy after a prolonged fascist-type dictatorship, Franco regime, under terrorist threat and under terrorist violence. So we had very good reasons in our written constitution to strike a balance between liberty and security. That has not been the case of every member state in the European Union. So that means that a legal, how could I say, a legal cultural ground to strike the balance between liberty and security has not always been written in each one of the experiences of the member states of the European Union. It's something we gotta work on. Not easily. It's something we really gotta work hard on to make sure that we do the proper thing. And we've had a number of occasions to show this in just 1 year of the European legislature. I would refer to a very particular example which I think is meaningful. Expresses very well what I'm trying to point out. It's the discussion and the debate about a bilateral agreement between the European Union and the United States for the purposes of fighting terrorism. We've done it more than once because we are negotiating with the United States a number of agreements. First of all, the legal background for it is to understand that the Lisbon Treaty has also meant an strengthening of the capacities of the European Parliament to have a say when it comes to negotiating and concluding international agreements on behalf of the European Union. Firstly, the European Parliament had nothing to say about them. Now, not only we got something to say, we have a final say. And without this final say of the European Parliament, there's no agreement at all. Article 2018, if my memory is not, does not get me wrong, of the Treaty of Functioning of the European Union, makes it clear that the European Parliament is to uphold or withhold consent to every international agreement negotiated by the European Union with third parties, which includes, of course, the United States in international law. That has been the case of a number of agreements we've been negotiating. The PNR, passenger names record, the General Agreement on Data Protection, which is underway, but I would say most significantly, the so-called SWIFT agreement. SWIFT agreement is the way that somehow the daily papers and journalists have called an agreement which was never officially named SWIFT, but TFTP, Terrorist Finance Tracking Program. TFTP. The point about this agreement is that makes it possible for the intelligence services of the US Treasury to track the financiation of terrorist cells, terrorist organizations, or terrorist attacks in order to prevent terrorist attacks from ever happening, not only on American soil, but on European soil too. This information was provided by a private Belgian-based European corporation by the name of SWIFT, meaning Society for Worldwide Interfinancial Telecommunications, SWIFT. That's the name of this enterprise. And this agreement was concluded by the European Commission with the United States right before the Lisbon Treaty finally entered into force. But the Lisbon Treaty finally entered into force, which means that Lisbon regulation, Lisbon system was applicable. And the treaty was not to be effective if not with the consent of the European Parliament. The European Parliament said no to this agreement negotiated by the European Commission in a vote that took place in February. That was a major blow for the Commission, was a major blow for the Council, because it had been negotiated and finalized on the Swedish presidency, it was a major blow for the United States too. It was a major blow in the so-called transatlantic dialogue and the transatlantic dimension of the will to cooperate between the European Union and the United States. So the situation was unclear, worrisome in that particular point of time. People would fear that the United States would resort to bilateral agreements with Belgium and the Netherlands, which are the seats, the physical seats for the services of this SWIFT system, or simply ignore the European Parliament. But the United States, wisely enough, did not resort to either. The United States promoted a new path of negotiation with the European Parliament and were receptive to the concerns and requirements of the European Parliament. And we were very active. We in the European Parliament, we were a very active negotiating partner in order to strike the proper balance between liberty and security. Incidentally, let me simply confess, acknowledge that I had the perception throughout this negotiation that a major problem behind this difficulty that had to be overcome was related to the fact that the American legal system is widely misperceived among the members of the European Parliament. I mean, it's not hard to understand that many of the members of the European Parliament have prejudices about the American legal system. It's easily understandable. They think that the European Parliament and the European legal system is concerned about privacy and rights, but the American legal system is overwhelmingly inclined to overemphasize the importance of security. And somehow the Americans have gone hysterical about security and have forsaken rights and privacy, which is not true. I've never thought it. I don't think that's a fair assessment. But I think that's an impression that somehow is widely spread among members of the European Parliament, widely spread. And people think that all of the measures that were adopted by the US Congress and by executive decrees by the US presidency after 9/11 were simply showing that the United States had abandoned their constitutional tradition to protect rights of the citizens just for the sake of a security hysteria. So it was a difficult negotiation and a difficult path to cover. But I think we made it, and we showed strength on the part of the European Parliament. We made it right. And we not only were influential, even decisive, in order to make our points in the drafting of the new agreement. Not only that, we even managed to reopen the negotiation by the Council once the Commission had completed officially her negotiating role, her negotiating part. Late June, early July, this negotiation was reopened in order to make a final effort to meet the needs and concerns of the European Parliament. We did it. We did it. I think the final draft of the agreement, the new version of the TFTP, first comprehends a balanced answer to the main question of proportionality and necessity when it comes to setting limits to rights which are enshrined by the European Charter of Fundamental Rights. Second, makes it sure for the European citizens that they are given legal and judicial redress before the US authorities when it comes to protecting their privacy. Third, make sure that the European Union is given access to the operation of data extraction on American soil by the appointment of a US representative official to follow track of every operation with a very strict purpose limitation clause to make sure that the whole operation of data extraction is related to prevent terrorist attacks from ever happening. And fourth, establishes a mandate for the European Commission to work on a European TFTP, which is to be adopted in a 5-year term. In 1 year, the European Commission is going to submit a project, a draft bill in order to establish a European TFTP, and a 3-year term, we're going to have to have an assessment of the progress of this European side of the so-called twin-track approach, so that we can cooperate with the United States with the same purpose of preventing terrorist attacks. I think, and this is my final point, this shows that the European Parliament is taking time, trouble, and it's not going to come easy, but it's making progress in order to metabolize, in order to incorporate its new capacities. The European Parliament is making progress in order to take seriously the new enhanced, strengthened role that the Lisbon Treaty has contemplated for the sole body of the European structure, which represents directly, on a representative and democratically elected basis, the whole of the European citizens. Having said all this, my last word will have a self-criticist and self-demanding character in order to say it bluntly, that I am appalled by the fact that the strongest parliament in Europe, which is the European Parliament, and the strongest European Parliament in the whole history of the European Union, is a parliament that is so scarcely known, so scarcely appreciated, and so scarcely perceived as the major force, as the major power it really is. I am appalled by the fact that the European Parliament is discussing serious matter and hardly ever seen by the European citizens we claim to represent. I am appalled by the fact that this strongest European Parliament of the whole of the European history has been voted just by the 40% of the people who had the right to do so, to vote the European Parliament. I am appalled by the fact that there is no indication at all that we are correcting this drive. On the contrary, my perception is that the financial and economic crisis has been accompanied by a political and social crisis which is driving away more citizens from politics than ever before in the history of the European construction, of the European project. I am appalled by the fact that there is an anti-politics drive across Europe, which is regarding politics with contempt, mistrust, despise, and resulting in an eruption of populism and political extremism across Europe, very anti-European. I am concerned about that. And I wanted to say this because I think if Europe is about citizens, that was my first statement, I gotta do my best. And I'm doing my best. I mean, right now, in order to do something about it, because I don't want to miss a single chance to show interest in facing this drive and do something not only for preventing it from going, but also to combating, correcting, and making it right. I thank you for your time.
Thank you very much.